All right. Good afternoon, everybody. Here we are on a snow day, and we're going to talk a little bit about what goes on in the judicial appointment process, how presidents help to choose their judges and justices, and so on, because we are, after all, off for snow. So really quickly, it's worth noting that the nomination and confirmation process itself is fairly simple, but it has a number of potential failure points. First off, when the president begins with a list of potential nominees, often a list of potential nominees which comes from interest groups like the Federalist Society or the American Constitution Society, there's a lot of pre-nomination vetting. Presidents usually take a look at the personal history and characteristics of their nominee. They go back and they read everything the nominee has written, all the way back to articles in their student newspaper when they were in high school. The president, whenever they pick a Supreme Court nominee, usually has a group of White House staff, personal advisors, who go through and do a lot of work on the nominees before they're actually even put before the Senate. Then the president nominates and introduces the new candidate to the public. This is often the beginning of a short but intense public relations campaign where the president sort of puts out an official bio for their new nominee, makes a speech to certain members of the House or Senate Judiciary Committee, and generally makes a case for their nominee publicly before the hearings begin. Then the Senate Judiciary Committee actually has a series of hearings, usually lasting anywhere from a few days to a week, where they spend most of each of those days just talking with the nominated individual. So the person who the president has nominated will come before the Senate Judiciary Committee. Each member of the Judiciary Committee will take a few minutes to make a speech about what they think about the nomination. There's kind of an opportunity for each senator to do a little bit of grandstanding. And then each senator on the committee gets to ask questions of the president's nominee, and the president's nominee has to answer under oath. This is really an opportunity not to catch the person out, but often to try to expose their particular views on hot button or other important issues. The next step is a vote in the Senate Judiciary Committee to send the person on to the full Senate. This is the place where you could end up failing, and as you see here on the right, there are a couple of paths that you can follow. The committee could vote to support you. The committee could vote to send you on to the Senate without support. The committee could send you on to the Senate with a negative report, or the committee could just not report because the person may decide they don't want to go through with the nomination. There are a number of things that happen. The debate by the full Senate is a normal Senate vote that used to be filibusterable, but the final vote as of last year is no longer filibusterable. So judges and justices at all levels cannot be filibustered during their confirmation appointments. The same as cabinet secretaries also can't be filibustered. So the filibuster today is only really useful for legislation, not for the confirmation of appointments. Finally, they end up not being confirmed if they get a majority vote, and a lot of justices do. It's relatively hard to fail once you get through the whole process effectively. And you get your seat, you get assigned which circuit you're going to be the presiding judge for, you have your clerks you pick out, all that good stuff happens. So that's the basic confirmation process. And it's intended to keep people who are unsuitable or partisan in some way often from getting onto the court. This has not always worked. It's been a very complex process. But from the beginning, John Marshall set up a series of norms for judges and for members of the federal judiciary about how they should act. That judges and members of the federal judiciary needed to be aware of the political nature of their appointments and not engage in electoral or partisan politics themselves, that they should maintain low public profiles, that they needed to have a relatively positive and cooperative attitude with their fellow judges. So ever since John Marshall, the first Chief Justice, sort of created a set of norms of behavior and expectations for judges, this has been an important part of who gets to be a federal judge and why they get to be a federal judge. Now, this is not always the case. There are plenty of people who end up in the federal judiciary who don't necessarily meet those standards, but very rarely do people who don't meet those standards end up on the federal Supreme Court. It's worth noting that all of the things that we're talking about here also go for circuit court judges and for district court judges. All of the circuit and district judges, the full judges on these courts, have lifetime terms and go through a similar process, though a lot less intense than that of a Supreme Court justice. Some of the circuit justices really are almost an intense process as the Supreme Court. The Circuit Court for DC, for example, that decides so many important and controversial issues, has a very rigorous appointment process. There are also magistrate judges, if you remember, who we talked about. They do not have life terms. So because they're not standard Article 3 judges, they're a little bit different. The court has also really evolved in its responsibilities and its approach over the 19th and 20th century. You don't need to know a lot about these details, but things like how the court went about monitoring the courts of appeals and the relationship between the federal courts of appeals and the Supreme Court, the way by which the federal government organized its district courts and its U.S. attorneys, the method by which the court would hear appeals or vote on things like writs of certiorari. All of these were very, very different in the 19th and early 20th centuries. The process of appointment was also very different until the 20th century, with this contemporary process of the House Judiciary Committee sitting down and talking to the nominee and so on. That all wasn't established until the early to mid 20th century. Although Supreme Court seats have always been regarded as important and as a crucial power of the presidency, the level of political controversy over who would be appointed to them, the amount of lobbying that went on Capitol Hill, and the intensity of the confirmation process really amped up in the mid 20th century. That's not to say that people didn't have failed judicial appointments due to political problems before, but they weren't usually concentrated on policy issues. The guy I have up there in the upper right is one of the first judges whose stances on policy issues helped to end in his defeat. The guy up there was a political appointee, I believe, of Truman. I'm suddenly blanking on this now that I'm not looking at my notes. Was an appointee of, I believe, Truman, whose views on racial issues and on railroad monopolies ended up landing him in the hot seat. Harold Craswell, who's our next person down there in the next left, was a Southern jurist who failed his confirmation hearings because the NAACP lobbied against him. And we'll talk about the guy on the bottom right, Bork, who failed his nomination hearing in the late 1980s a little bit later. So these are examples of the kind of people who started to fail at their nomination process despite being otherwise strong nominees, as the politics and interest group lobbying and public awareness around Supreme Court seats increased. Similarly, after about 1950 or 1970, the types of appointees who landed in seats ended up being much more limited. So, for example, Justice Earl Warren had been a mostly elected politician. He was the governor of California. He was an important member of the Republican Party all the way through the 1950s. And when he was appointed by Eisenhower, it wasn't seen as unusual or weird that someone who didn't have a long and storied career as a judge or lawyer was on the court. That was not considered too far out of the norm. As long as that person, once they were on the court, conformed to John Marshall's judicial norms of behavior, going back to the beginning. But after the late 1950s through 1970s shifted the expectations, very few people like Earl Warren would continue to land on the court. And today, to be considered for a Supreme Court seat, it's virtually required that one be a graduate of an extremely prestigious law school, that one have had a career as a federal bench lawyer or a judge, and to generally you have a very specific profile as a legal thinker. In fact, almost everyone on the court today went to one of the Ivy League law schools and had at least some previous career as a federal district court judge or other part of the federal system. For example, Elena Kagan is the closest we have to someone who had a political position on the court, and she was merely the U.S. Solicitor General, the role that deals with the court. And of course, these failed nominations that I mentioned are not the norm. Most judicial nominations to the Supreme Court do succeed. Most presidents encounter some difficulty in picking the right person. Sometimes people withdraw from the process or turn down a nomination, especially early in our country's history. But although they are high stakes, failed nominations are significantly less common than successful nominations. So how do you choose an appointee? Just so you know, these are our guys who are currently on the court here. Well, the first thing you do, of course, if you're a president trying to choose a judicial nominee, is you think about their judicial philosophy. Now, most presidents are not constitutional lawyers. They don't have very much education in the stuff that we've been discussing in class over the past few days about the nature of originalism and textualism and what the factors that judges like to think about are. And they certainly don't have a lot of deep reading in the subject. Obama was a little unusual in this way because he taught constitutional law, and so he was kind of different from the other judges, from the other presidents who have worked through this process. But most presidents do have some grasp of this notion of which judicial philosophy they prefer, with conservative presidents, Republican presidents, often preferring a judicial and political philosophy that is a little bit more textualist or originalist, and more liberal presidents, Democratic presidents, often preferring more values-oriented or pragmatic approaches to constitutional interpretation. That's not entirely universal. There are certainly exceptions and complications and wrinkles to that. But what's important about this is that presidents are not necessarily using partisan identity or direct politics. They're using judicial philosophy, which is only um, an incomplete heuristic for actual political philosophy. In some cases, they line up pretty well. Clarence Thomas is both a dedicated member of the Republican Party and a conservative judicial theorist with a deep belief in strong textualism and originalism. But it's not always the case. To go back to the example I used on the last slide, Earl Warren was a member of the Republican Party, but over time, his judicial philosophy proved contrary to what a lot of Republicans in elected office wanted done in policy and politics. So judicial philosophy is not a one-to-one guide to partisan loyalty. So don't think that when presidents choose justices, they're simply choosing loyal Republicans or loyal Democrats. They're choosing people based on judicial philosophy, which often has a lot to do with their politics, but isn't 100% a guide. Um, Presidents also choose justices based on various symbolic and demographic characteristics that they want to embrace. This is a really easy example, but one that doesn't really apply anymore. There used to be a regional balance on the court where presidents would try to choose a few people from the South, a few people from the Northeast, a few people from the Midwest, and one person from the West Coast. Especially in the lead up to the Civil War, there was a very specific regional balance with specifically Southern seats on the court. To nominate a Southerner if one of those seats went vacant, and so on. But today, the symbolism and demography of the court is often fairly partisan and often based on interest groups. For example, someone like a Neil Gorsuch was a symbolic pick because he's the only justice who didn't go to a Ivy League law education, and he's the only justice who comes from the Midwest. Everyone else grew up in either on the West Coast or in the Northeast. So that's sort of a way to look at the symbolism of someone like a Neil Gorsuch. At the same time, demographic characteristics, especially in today's contemporary partisan environment, are very important. Democrats put emphasis on selecting nominees from various minority groups. For example, Sonia Sotomayor is from Puerto Rico, Elena Kagan is Jewish, and Justice Ginsburg, of course, is was one of the first female justices on the court. There used to also be other demographic factors that people took into account. It was a big deal when the first Jewish justice was put on the court. It was a very big deal when the first Catholic justice was put on the court. But those particular demographic characteristics don't play a very strong role in contemporary picks for the court. Although it is worth noting that Neil Gorsuch is also the only Protestant currently on the court. Everyone else is either Jewish or Catholic. The other thing that you look for as a president in thinking about choosing your judicial nominees is their age, frankly. You don't want to choose any older judges. You want to choose young judges because when you choose young judges, if they get through the nomination process and are confirmed, they will serve for a long time. As you can see below here, of all of the Supreme Court judges who've served across our nation's history, the ones who were nominated and took their oath between the ages of 45 and 49 Many of them stayed on 30 or more years on the court. Similarly, if you look all the way down at the bottom, older justices, like those who were nominated between the ages of 55 and 59 or over the age of 60, didn't stay on nearly as long, and a much larger percentage of them stayed on the court less than 10 years. So presidents try their best to choose young and healthy justices. Incidentally, women do live slightly longer than men, so it's sometimes been discussed that presidents might do better choosing female justices if they want to maximize the length of time that someone will stay on the court. Um, and of course, once you've chosen someone, there's an extensive vetting process where the where the president or the president's staff, and then the Senate look at all of the opinions that person has written. In the modern age of social media, I'm sure that at some point a justice will get called out for a tweet they liked. This vetting and look at what the justice nominee has done in the past is very, very extensive. It's not just a check to see if they are, guilty of some form of corruption. It's all about their judicial philosophy and so on. Finally, in non-Supreme Court nominations, that is circuit and district court nominations, Congress has a much more important role, as do interest groups, than in actual Supreme Court nominations. In particular, for a long time, last year, there was a tradition in the Senate called the blue slip tradition, which was that when the president picked a district court nominee for a state, say the district court that covers South Dakota or the Western District of Virginia, the president would go to the senators for that state and basically ask them for permission to nominate a certain person or ask them if they had someone that they wanted nominated for that seat. Now, that particular tradition has gone by the wayside in the Senate as of last year, but it may well come back, and it was an important example of the role that the Congress used to play and still does to a lesser degree in choosing and helping to nominate the people who they will confirm for district and circuit court judgeships. The modern appointment process itself, once you get the president having chosen their nominee based on all of those factors and based on the judicial norms established by Marshall, is very, very different today than it was in the early to mid 20th century or even in the 1970s, because the highly polarized nature of our contemporary Congress and the increasingly media-driven way the appointment rollout by the president and the hearings and in the Senate go have really introduced a level of intensity and sort of adversarialism to the appointment process, especially the confirmation process in the Senate, that really wasn't present. We call it sort of today appointment hardball. And there's really three stories that can help us to understand this. One is the nomination of Judge Robert Bork, and he is one of the few Supreme Court justices who has the honor of having entered U.S. slang, and this is an entry from the Merriam-Webster dictionary up here, for the organized campaign to defeat his nomination in 1987. Bork was a controversial figure not just because of his very conservative judicial views, which were, sort of what was to be expected from someone like Ronald Reagan doing the appointing, but also because he had played a role in Watergate. Bork was a loyalist to Nixon in the White House, in the Attorney General's office, during the Watergate scandals, and had been one of the actors in what was called the Saturday Night Massacre. So between his fairly conservative judicial views, some of the public statements that he had made earlier in his life having to do with topics like race, and especially about abortion, and his long-standing role in earlier political controversies, Bork was subject to a widespread public campaign that featured things like television commercials to voters in the states of the senators on the Judiciary Committee, that featured long media interviews with people who had known him, extremely strong language coming from the Senate Judiciary Committee's Democratic leader, a senator named Joe Biden. I don't know if you recognize that name. All of which combined to force his defeat in one of the first really public, really deeply divisive appointment issues. Now, remember that I pointed out some of the failed nominees from earlier in American history, people like Craswell, or Johnson. but not very many of those nominees failed in quite the same way due to a large-scale political campaign, a large-scale public campaign, as Bork did. Harriet Miers is another example of this. Harriet Miers was a loyalist to George W. Bush, who had served in his administrations in Texas all the way through the 1990s, who had served in his White House until 2005 as one of the president's office of legal counsel, so not in the Attorney General or the Solicitor General's office, but in the White House Office of Legal Counsel, um, and was generally considered a personal friend of the Bush family, as well as a pretty sharp legal mind. But Myers's nomination quickly became bogged down in the Senate judiciary part of the process. And the amount of criticism and investigation that was leveled against all of her activities in Texas in the 1990s, all of the various columns that she had published, and the fact that she had no judicial experience, despite having been a lawyer for the Bush family and for the Office of Legal Counsel, led to her decision to actually quit the nomination process partway through. She decided that ultimately she stood very little chance of succeeding in the vote of the Senate Judiciary Committee, and certainly not on the Senate floor, and that she didn't want to endure the kind of attacks and deep investigation she was receiving, and she just left the process. The last example of appointment hardball is Judge Merrick Garland. Judge Merrick Garland was picked for the vacancy that was left by Antonin Scalia's death in the last year of Obama's presidency, when Scalia died in 2015. And in that case, the Senate was controlled by Republicans, who therefore controlled the Senate Judiciary Committee. Rather than engaging in sort of a public campaign to defeat Garland's nomination, the Senate Judiciary Committee simply refused to even have a nomination hearing for Garland, saying it was up to them whether they wanted to even go through the process. And they made it clear that whoever the president chose, it wasn't that Garland was a particularly bad choice, it's that they would simply not confirm any Supreme Court justice chosen by Barack Obama to fill the seat left vacant by Antonin Scalia, except if the president chose a strong Republican to fill that seat, or a strong conservative jurist to fill that seat. So Garland is an interesting example because it's not quite the same as the Bork or Myers example of a large-scale political campaign to defeat a nomination, but instead of the Senate simply using its powers to the absolute maximum effect by refusing to even go through the confirmation process for a nominee. Some of the things that have created this contemporary environment are the fact that it's much easier now than it ever has been to do legal research and to do personal research on the individuals who are nominated. In 1970, if you wanted to find out all of the different judicial opinions that someone had written or read the papers they wrote in law school, you often had to go physically from court to court around the United States where they might have argued as a lawyer or served as a lower court judge, and find and read those opinions. But in the contemporary world, all of that stuff is accessible, indexed, and searchable online through modern legal databases. And you can even find, small notes that they've written as addenda to other judges' opinions in this way. So the ease of modern personal and legal research, in particular, and the existence of organized interest groups like Judicial Watch on the conservative side, whose goal is to engage in research about these nominees, has really increased the ferocity of the nomination process and the confirmation process. There's also an increasing pressure that is part of the norms that were established by John Marshall, but has become more intense in recent years, of not pre-deciding issues. Now, this has always been a norm for people nominated for the court, that if in front of the Senate nomination hearing, they're asked, how would you decide on a case about topic X, where topic X is something like gay marriage or abortion and so on, the justice always will say, I don't ever pre-decide a case. I would hear the case, I would hear the arguments, and I would compose a response. Now, the senators will often ask the nominee more generalized questions. How do you feel about the right to medical privacy? which implies the right to abortion. But there's a lot of pressure for nominees not to give away their position on specific issues by saying that they can't pre-decide cases. Um, and that pressure has made the nomination and confirmation process, especially at the hearings, a real obstacle course as question after question comes at the nominee and they have to avoid trying to tip a hand about how they feel about an issue. If they do tip that hand, they would be breaking the norm. Earlier judges and justices who were nominated didn't have to go through as many days of public hearings, and this norm was a little bit less intensely enforced. Whew, okay.